Hi everyone, the next instalment of videos on the Employment Rights Bill focuses on the protection for 0 hours workers. So these are individuals who are given a contract which does not require the employer to offer any particular number of hours. The concern of many governments in the past has been that these are potentially exploitative and give too much power to an employer to arrange the work how they see fit. And for there to be no real penalties when cancelling shifts at short notice, which can obviously be to the financial detriment of the worker themselves. So the new Employment Rights Bill sets out a number of provisions in relation to 0 hours and low hours contract workers. So one of the first concerns was that if an employer gave a contract that only required a minimum of 30 minutes of work each week, they could potentially circumvent the protection that the government was trying to afford. No definition of what a low hours contract is, but essentially at a certain level, employers will be caught by the certain provisions. So for example, if you provide a contract which doesn't provide or guarantee more than say 5 or 10 hours of work, the legislation is going to then set out what may apply. And the most important aspect of the bill is that it will introduce a right to a guaranteed hours contract. So after a defined period of time, an eligible worker who has picked up regular hours over a particular reference period, yet to be determined, can be entitled to a guaranteed hours contract. So that's a document that will give them a guaranteed number of hours to be worked in each week, akin to a permanent member of staff. So it removes that exploitation there of somebody having potentially infinite amounts of uncertainty in their arrangements for work. And if that contract is not offered by the employer, the suggestion in the bill is that the employer has the right to bring a tribunal claim and to claim financial loss for the earnings that they would have received had they been provided with that guaranteed hours contract. The bill also suggests there will be a cap on that compensation, but it is a very positive and potentially powerful step forward that businesses are going to have to be aware of. If the employer does offer a guaranteed hours contract, there is no obligation on the individual to accept it because legitimately they may want the freedom of a genuine 0 hours contract. There's also provisions in there in the bill about changing shifts at short notice, cancelling shifts, and providing certain amounts of notice for shifts to be worked. This all hinges on the definition of reasonableness, and there's nothing in the bill which states what will be reasonable, but the intention is there. The intention is to create as much certainty as possible for the 0 hours worker on an ongoing basis. And if that can't be provided, so if reasonable notice of a change or reasonable notice of cancellation can't be provided, the suggestion is that some compensation will be awarded to the worker in those circumstances. So as you can see, still lots and lots of uncertainty about how this will play out in practice, but the concept of a guaranteed hours contract is certainly going to be there once the legislation comes into force. If you do need anything on this, on the Employment Rights Bill or employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.